We arrive at the final part of the lecture, and following your notes, the next heading that you see here would be concerning remedies of the parties, and this is something which your subject guide does not deal with, and it's in your notes. You can go back and read on your own. I won't want to go through this with you because it's really something which is fairly detailed already in your notes and not too examinable, right? What I do want to cover with you, really, is this last bit here. And this is dealing with the title of Termination of Agency. Now again, your subject guide deals with this area very briefly. It seems to indicate that it might not be important nor examinable, even insofar as the past year questions. It's a very small issue. But still, I want to cover this with you because there is one part of termination of agency which in practice is extremely important, and that is insofar as how the commercial agents regulation regulate the termination of the agency and providing certain rights to an agent. Upon termination of the agency, you find that there is this regulation 17 that provides fairly significant new rights to that commercial agent, which does not exist at all for the English agent that operates within common law. And so given that significant advantage that a commercial agent has within the regulation, I want to touch on that shortly in this particular lecture. But just so that you can look at these notes now, when we talk about the termination of agency, it's pretty straightforward. As you can see how there are these two ways of how an agency can be terminated. Firstly, of course, it can be terminated now by act of the parties, and of course, secondly, now by operation of law. Right? These are these two methods. And within termination by the parties, there are of course these three further ways of how it can be terminated, such as, for example, where the parties were to mutually consent or agree for the agency to be terminated. And that's obviously where no issue will arise because both of them agree to terminate. Or it may even be where there is revocation of authority by the principal. Now, no doubt, agency could be created by way of a contract, but still, the main basis of agency law is authority. And so, the principal can authorize the agent. Similarly, the principal can revoke or take away the authority. And so this is what we see here now. Of course, there are some exceptions as to when the principal can't revoke the authority. For instance, where the authority has already been exercised. You're halfway through doing the act, for instance. So there are these kind of exceptions that we don't see in exams, but as you can read here from your notes. Of course, the third and final way would be where you find that you could give notice, right? The difference between 2 and 3 is where in 2 there is the provision of notice by either party, the principal of course, or as with the agent. So even the agent himself, even though he might be appointed the agent, but at any point in time he wishes to terminate, he can do so. Now, however, when I talk about this point 2 and point 3, and where we are saying that both principal or agent may revoke the agency or terminate the agency, but you need to also recognize that assuming that this was an agency that was by way of contract, then therefore there will be the additional contractual laws that will also apply. In other words, based on agency law, the answer is yes. The parties can terminate the agency by giving notice, or even without notice, where the principal can just renounce or revoke the authority. But whilst that may arise, there is a parallel regime that applies, which is contract law, and where contract law may give rise to contractual implications, in that if you were to revoke the contract agency before it's terminated, or rather before the expiry of the agency duration, then there could be contractual implications. So for example, we could be dealing with an agency where it's a 5-year contract, and after 3 years you want to terminate. The answer is yes. Agency law will allow you to terminate because agency is based on authority, and the moment the principal revokes the authority, that's it, there's no more agency. However, this will give rise to a contractual action that the agent may have against the principal, where the agent may sue the principal for breach of contract. Not so much as breach of agency, but breach of contract, right? So what you want to understand is that there will be two concurrent models, so to speak, that would arise. One is agency and the other is contract. And this is how we understand termination of agency, as with, of course, the relationship between contract and agency. Now, insofar as operation of law is concerned, what we mean is that this arises automatically. That's why we say that it is by operation of law, and that it is without the need of any intention. So regardless of whether the parties intend or not, doesn't matter, it is automatic, right, by operation of law. So for example, you find here what we have covered before in contract law, in that where there was frustration of a contract, that would terminate the contract by operation of law automatically. Likewise here for agency. Likewise, of course, if you deal with instances like bankruptcy or insolvency, situations of where the principal agent dies or becomes insane, right? So when you look at points 3, 4, and 5, this gives you a very clear, good picture of instances or examples of what we mean by agency that terminates by operation of law. Now we arrive at looking at this termination of agency and how it is impacted or affected by the CAR, right? And in your notes you have this part as well, and then you can read regulation 14, 15, 16, and 17. But in particular, I want to put a 3-star, in fact 5-star, right, over here to regulation 17 sub 1, because this part is a part that's really, really important. But before that, let me just address something very minor here. The other possibly significant section or regulation here will be by virtue of regulation 15. I can put 1 star here now, just to show that it's of some importance, where we deal with minimum periods of notice to terminate the agency. And it's like pretty much, say, your employment contract, where you must give your 1 month or 3 month notice before you resign from your company. Something similar here, in that in relation to commercial agency, you find that in order for either party, it's not just applicable to the principal, but it's to either party who wishes to terminate, he can do so, but this will be only if he provides notice. And you find that the regulation is prescriptive. It prescribes certain minimum periods as to the notice period you must give in order for the agency to be terminated. And by virtue of regulation 15.3, you find that you can always agree on longer periods, of course, but it must not be shorter than what is to be observed by the commercial agent. And obviously, whilst it can be longer, it also can't be shorter than what is prescribed here by 15.2. So what you are seeing here in 15.2 is the minimum. It can't be shorter than that. It can be longer, of course. But even where it's to be shorter, it can never be shorter than that which is observed by the commercial agent. So you are seeing a picture here in 15 where it's trying to provide the agent with certain rights that he would again not have within common law. If you were to look at common law agency, is, as I mentioned earlier on, pretty much contractual, and so there really wouldn't be any minimum periods which the law prescribes. It is for the parties themselves to agree, and it could be 1 month or shorter. It could be 3 months or shorter. And so in that regard, you find the commercial agents regulation, insofar as a commercial agency is concerned, is good for the parties in that there are certain minimum periods that you must follow. Now, but it's just a 1 star point, which is not too important. I want to come back now to here, dealing with regulation 17, and this part's important. And you find that, as the title suggests, there's this right given to a commercial agent, where it's a right for him to either to receive indemnity or compensation. But these two rights he has for indemnity or compensation is a right he has upon termination of agency contract. In other words, this is a case of where the agency has ended. For example, it had expired, the 5-year appointment of the agent has come to an end, and so naturally speaking, even by way of contract law or common law, you find that when the agency ends after 5 years, then the parties will part ways and just walk. Neither party would owe to the other party any further obligations. Of course, during the 5-year period, there will be a need for commission or payment or indemnity as what is relevant, but upon termination, the contract ends, so neither party would owe anyone anything anymore. But very interestingly is where Regulation 17 seems to provide for the commercial agent this very significant right, or rights plural, in that he has either the rights of indemnity or compensation even though the agency has been terminated. Now, in case you are confused and you think of indemnity or compensation as certain things or benefits we provide the agent for his losses suffered, I want to clarify that this concept that we're referring to within indemnity or compensation is not based on any loss suffered. Let me illustrate this here in your slide, that when we talk about Regulation 17 and when we talk about the concepts of indemnity and compensation, then you must realize that this indemnity is actually based on a German concept or German rule, German principle, whereas insofar as compensation that you see here now, although yes, I know that we do use this similar words, similar term in UK or English law, but it has a different meaning. It's based on the French concept. Again, you must appreciate what I said before, that the CAR is of an EU influenced, and so when the drafters drafted this code, they were influenced by the German and French concepts of indemnity and compensation. And both these concepts really, I wish to clarify, are concepts which allow for a commercial agent to receive this entitlement, and it's not premised, right? It's not based on any losses suffered by the agent. So although, and this part really is the part I want to put a star now as important, that although the agent had not suffered any loss, he can still sue for compensation. And this is what is unique, and in fact I must say is totally alien or new or different to an English agent. In that within England, under common law, you find that if I were to sue you and to receive compensation, there can only be compensation for actual losses suffered. And you know this, right? In contract law, the topic of damages or compensation, we said that there's only if there's actual losses suffered. And where there are no actual losses suffered, then you will not be entitled to any compensation. But insofar as Regulation 17 is concerned, I want you to understand as you read this further, the specific provisions that is not based on any loss suffered. So you may ask me, well, if it's not based on loss suffered, what is it based on, right? And the answer is this: it is really now, in some sense, the way to understand this, to reward the agent for his efforts, for the goodwill of the agency. It is to reward the agent for his efforts and for the goodwill of the agency. In other words, it is to recognize all the past efforts that the agent has put in and to give him now an amount. I suppose one way for us to understand this would be like maybe a bonus, in that as an employee, you work very hard, and although this is not something that you might be contractually be entitled to, but based on your performance, the company can declare a bonus, right? But still, the bonus is discretionary, at the discretion of the employee and based on performance. It's not something that you are entitled to. What we're now seeing here is this, that this is a statutory or rather regulatory entitlement where the law prescribes and say that this is what the agent can ask for recognizing his efforts and goodwill. Now that I've introduced these two concepts, the other thing I want to explain further is this, that you have indemnity and then you have compensation. So which one is it that we use, and whether within these two German and French concepts is there a difference? And this is interesting because when the code was first drafted, member states in EU were supposed to choose either one, as in to choose either to implement the German scheme of indemnity or to choose to implement the French concept of compensation. What UK did was they decided now to take both or choose both. And so you'll find here, for instance, in Regulation 17.1 itself, it says very clearly that the commercial agent is entitled to be indemnified or compensated, right? So I put here now, right, just to highlight this particularly, that as far as the commercial agent is concerned, is a choice, right, to either go for indemnity or compensation. And this was a part I said where it's unique, so to speak, to UK, in that they have incorporated both concepts into the regulation, giving to the agent a choice of one or the other. But of course, although there was a choice, there's also a default rule or a general rule that will be applicable, and this is by virtue of Regulation 17.2. It says that except where the agency contract provides otherwise, it means if the contract does not say otherwise, the commercial agent shall be entitled to compensation. So I put this here now, right, as the key phrase, where clearly now the law is stating that the agent shall be compensated rather than indemnified. And so one way to understand this is that you can view this perhaps now as a default rule or as a general rule, that it applies, right, unless the contract says otherwise. So it's subject to the parties' contract intention. So if you don't say so, your contract of agency is silent, then you will be entitled to compensation, right? And in a way, compensation is better for a few reasons. In fact, there are 4 reasons I'll show you afterwards in your notes as to why it's better. But for now, let's just understand better what is compensation and what is indemnity. Now, Regulation 17.3 and 4 then talks about indemnity, right? So you find here that where it talks about the commercial agent being entitled to indemnity, but provided that they satisfy 2 conditions. So let me just try to structure for you now your notes on this, where we want to now look at the concept of indemnity, and you find that the starting point would be where we want to look at Regulation 17 sub 3 that lays down for us the 2 conditions. Okay, so Regulation 17 sub 3 would lay down for us the 2 conditions that will have to be satisfied for you to be entitled to indemnity. These are 2 conditions that you see here now, where firstly, he, as in the agent, has brought to the principal new customers, or has significantly increased the volume of business with customers. So you find that you need to satisfy either because of new customers. If I just put it here now, right, 2 conditions, in that you have the first, in that there were new customers being brought to the principal, or number 2, where you have increased the business. So this may not be new customers, but it could be where they are existing customers and the agent has managed to get them to buy more goods perhaps. And so overall, he has increased the business or maybe this could be where there are new products, and this was an agent that was instrumental to market new products and increasing the business of the agency, right? So either one or two, right? But what is important is this, is that a part of these two conditions, there are also two other further additional rider conditions, right? I put it here now, and, right? And we must also show, and I put now as A and B, A, that the payment is equitable. So although you may be able to show that there are new customers, but there is this concept of equity coming in, and which means to say that you will not be compensated beyond an amount that might be inequitable to the principal. It's really a case of where the regulation is trying to strike a balance. On one hand, we have to recognize your efforts, but then again, on the other hand, you must also recognize the interests of the principal and whether overall it's equitable for that amount to be indemnified to you, right? And here, we want to understand how, in order for the indemnity to be provided, that apart from this equity, is this also earlier part, which I've missed out, and, right, and the principal continues to derive substantial benefits from the business with such customers, right? So maybe I just put here now, I just change the order a little bit. This would be B, this A, right? And the principal continues to derive substantial benefits. So it's not a case so much as where it's a one-off effort by the agent, but efforts has resulted in a continual benefit to the agent, as well as where the payment is equitable. So I think this particular Regulation 73 is good. It gives you two conditions, right? But and it's new customers or the business. But not only that, you must also go on to show this additional criteria to be satisfied of P deriving substantial benefits and the payment is equitable. Now then there is this other so-called cap, which I want to discuss with you. I'll just put it here now, where there is this point 2, and this is Regulation 17 subsection 4 that talks about the cap or the limit insofar as the amount is concerned on the amount. And you can see here now in your notes where the amount shall not exceed a figure equivalent to an indemnity of 1 year calculated based on the average remuneration over the past 5 years, right? So there is in a sense now a 1 year cap. And the way they calculate the cap is over the gross earnings the past 5 years on average. So in that sense, straight away you may realize that between indemnity and compensation is not so good, because you have all these conditions and requirements, as well as where you have this cap which is only 1 year. Which means to say that if even though the agent have done a lot of work, resulted in a lot of benefits for the principal, but there is still a cap on how much he can benefit as indemnity under Regulation 17, right? Now, then the next part is where we want to look at compensation. But before that, there is also this minor section or subsection in 17.5 that says the grant of indemnity shall not prevent the commercial agent from seeking damages, right? So this was what I said earlier on, that the concept of indemnity is not about damages. It's not about compensating the agent for any loss. That is where we want to just recognize the efforts and give all these amounts. And now in subsection 5 we then say, but if the agent has also suffered losses, then he can also choose to sue for damages. So you can get indemnity to reward you, and you get damages to compensate you for your loss. And this is the part now that of course we are familiar with as an English law student, in recognizing how for losses suffered there's compensation by way of damages, which is what we're now seeing here now, right? Damages. Now moving on further now to compensation. And this is by virtue of Regulation 17, subsection 7. So you find that for compensation, this will be regulated by different subsections. Still 17, of course, but in particular, the main starting point for us now is Regulation 17.7, right? And what 17.7 does is, again, laying down for us certain conditions. So I'm trying to follow a similar format to what I used just now, where in the previous slide I say that there are certain conditions, right, to be satisfied. So sitting here now, where we are now also looking at conditions to be satisfied for compensation, and these are the conditions within 17.7, where we say that for purpose of these regulations, such damage shall be deemed to occur. Now again, the word damage here used is not referring to any loss suffered. You will see this now further, where you are deemed to have suffered damage, particularly in the following circumstances, which is where it deprives the commercial agent, which a proper performance of the agency contract would have procured for him, or where it is not allowed him to amortize the costs and expenses that the agent has incurred during the agency contract. So to put it on the board now, or on this slide, the two conditions is as follows. Where firstly, this is now where it is to compensate the agent for the proper performance of the agency contract, for having done his job. He is now to be recognized and to be given compensation. He must again recognize that this is over and above his commission he's received, but now for the proper performance of the agency contract, then he now gets compensated. This is like where you have done a good job and at the year end your boss gives you a bonus. That's what I said earlier on. Now I'm going to put this in add one more first, right? B. The second condition, so to speak, right? And it's either one or the other, or where the agent has not been able to amortize his costs and expenses. This of course is an accounting term, and when we talk about amortizing costs and expenses, what we mean is this, that say for example the agent has spent in the initial period when he was first appointed as the agent, he could have spent 100,000 set up as capital, maybe to set up an office, to order goods, to do marketing, right? And all this of course will be costs he will want to recover from the profits, and he may have 5 years to do so. But it could be that due to his own incompetence, maybe due to rising costs, or even for the matter now, slow profits, he has not been able to amortize his costs and expenses. Then that is where we now have to compensate him. Now, this is quite an interesting concept, because if you are a businessman, you realize this, that if I were to appoint you to be my agent, and I give you 5 years as my agent, you want to make sure that within the 5 years, you were to be able to at least get back or capture back all the initial capital expenses that you have incurred, and over and above that, of course, to get extra profits. Now, if for any reason that you had not been doing a very good job, for whatever reasons, then too bad, that capital you have spent is sunk, it's gone, it's burnt. Surely you can't come to me to say, well, Mr. Chang, I couldn't get back my rental for my office, please pay me back. Right? That's obviously something that is strange and overtly generous if I were to give it to you. But this is exactly what Regulation 17 is allowing for, in that for all the expenses and costs that you have incurred for or toward the agency contract, and you have not been able to recover those costs back, to amortize those costs back, then therefore Regulation 17.7 allows for a compensation of that. And so you're seeing a very generous picture. Now, here is where then of course we have various cases later that will help us understand more of how it's calculated. But for now, you can see the two schemes of benefit to the agent. The earlier point was concerning indemnity. Now here is concerning compensation. Now then there is one final regulation which I want to address. This is this regulation 18. Not very important, but something which I believe that you would or you should discuss in the examination if you are discussing Regulation 17. Look at the heading here. For instance, it says that the compensation referred to above shall not be payable to the commercial agent. Where? And then they provide some circumstances. So they are dealing with what? Where the compensation or the indemnity above shall not be payable. So one way to understand this is to recognize this as perhaps now that this is like a limitation or an exception. So exception or exceptions to Regulation 17, which is exceptions to compensation and indemnity. And we are laying down now the various situations or exceptions as to when you don't need to compensate. So obviously, if I were to ask you now, so maybe I put here now in brackets now, the effect is this, right? Therefore, put in brackets now, that the principal will not need to pay the commission agent. Now if I ask you now, between these two sections, which is a section that will be relied on by P and which is the regulation relied on by A? And clear now here will be where it is to be relied on by P, because now P will not need to compensate if Regulation 18 applies, right? So as to what is Regulation 18, shortly afterwards. But just back to the earlier two slides, Regulation 17, right? For both indemnity and compensation, this will be obviously now relied by the agent, okay? Because if the agent is able to successfully satisfy the provisions in Regulation 17, he can get either indemnity or compensation, as explained just now. So while 17 is relied on by the commercial agent, and they can either be indemnified or compensated, but 18 instead will be relied on by the principal, where the principal will want to deny the payment and say that these amounts are not payable. Okay, now let's look at now Regulation 18 to understand what are the conditions for which one can refuse compensation or indemnity to the agent. And so now here you find A, where the principal has terminated the agency contract because it was due to a fault of the commercial agent, which would justify immediate termination of the agency. So obviously now, one situation, what you now see here now, I put as A perhaps, is that where P has terminated the agent due to the agent's fault. So if P has terminated the agent due to A's fault, obviously then I don't need to still pay you compensation, right? But on the other hand, if I terminate and it's not your fault, that is where I must compensate, right? Then of course we have the other one, or the other situation, which is where the commercial agent has himself terminated the agency contract unless such termination is justified by circumstances attributable to the principal. Now B is possibly a confusing regulation because within that there is like an exception to an exception. So now here it says, right, first of all, where the agent has himself terminated the agency contract. So here now, right? So where A himself terminates the agency. Now obviously, if this is a case of where A himself had terminated the agency, then he should not be given any compensation. We understand this, right? But now then you see here now, unless. So the unless tells you how there is now an exception to the exception. Right? So this exception or this unless part is applicable only to B. Okay? So I put here now unless. Unless the reason for why A himself terminated the agency is due to circumstances that are attributable to the principal, or due to his old age or infirmity or illness or any circumstance where the agent is unable to continue on his activities, right? So unless, and then you find here now 1, 2, 3, right? First is due to fault of the principal. 2 is, for instance, now due to age, illness, or incapacity in a very broad sense, okay? And where basically the point is that he's unable, right, to carry on his duties, unable to continue his activities. And the moment it is so, is where now you find that the regulation 18 would not apply. Let me just explain this one more time. Starting with the first line here, if it's a case of the agent himself terminates agency, then you can't be getting compensation. But if the reason why A terminates agency is due to the fault of the principal, if there was a principal who had somehow forced him to, or behaved in a manner that's very unreasonable and has been very harsh to the agent, behaved inequitably with the agent, and the circumstance has caused the agent to resign or to terminate. Which means to say that the reason why the agent is terminating the agency is due to the fault of the principal. Now, if that were to be the case, then therefore the agent would still be entitled to compensation. Regulation 18 would now not apply, because this is an exception to Regulation 18, right? Or it can also be unless where it's due to age, illness, or incapacity. So it may be a case of where the reason why I cannot carry on my activities, the reason why I terminate the agency is because I'm getting old, I'm sick, I'm handicapped, there's been a severe accident, I'm now physically incapable of discharging my duties. This is where or why I terminate. In those instances, you find that Regulation 18 is also excluded and 17 will still apply, and that the agent is still entitled to compensation or indemnity. So you find the law in that sense very fair, in that they recognize that sometimes, although A himself may be the one who end the agency, but it could be due to circumstances outside his control, due to the principal's own fault. Therefore, we will still want to preserve for him the compensation or indemnity in Regulation 17. And so we are at the tail end of this regulation. One last bit, of course, is this, that you want to take note, and I want to go back now to the earlier Regulation 17 here, by virtue of Regulation 17 subsection 9, where there's a time frame, okay, is that it must be within 1 year. So what I'll do is I'll add this up here, right, to your slide here, in that when we talk about indemnity and compensation, right, the third point is this, that A must apply, or A must apply within 1 year of the termination. So although this is a generous provision, but there's a time frame to it, and you must do so within 1 year, giving notice to, or rather apply or give notice, right, to the principal in order for you to receive your entitlement under Regulation 17. Now in your notes you have several cases that illustrates how these two concepts operate. And all these cases are not at all found in your subject guide, but it's here, right? So you can go through and read on your own to have a fair picture of how we calculate indemnity or how we calculate compensation. But I want to just focus on one particular case, and that is on the case of Lonsdale and Harlem. And you find Lonsdale Harlem here in the last part, or last few pages of the notes now. So here, I put a 3-star, and I highlight this as important, where we want to look at the position today and the case by the House of Lords of Lonsdale. But before I carry on, to put this case into context, this is a case on compensation, right? So in case you're confused, of course we didn't go through and read the earlier parts, but if you were to follow your notes, the earlier cases had dealt with indemnity, dealt with compensation, and now this current case is discussing compensation. So again, if you're doing your notes now, or your slides here, what you could do is that under compensation, the key case, right, as to how we calculate is the case of Lonsdale, right? And this case is important because it explains to us now, when we were to compensate, how much do we compensate? You may have realized by now that the earlier provisions on indemnity had provided a method of calculation. In that, the calculation is based on a 1-year amount, a 1-year cap, right? And a 1-year amount based on the past 5 years gross earnings. So we saw this in Regulation 17.4, where there was a method of calculation for indemnity. But interestingly, there's no equivalent method of calculation for compensation. The regulations, in a sense, is silent. And so as a result, therefore, we have had numerous cases. And so the case now that we have to clarify how much to get is this case of Lonsdale. That's why I put this case as important, and as 3-star, it's under compensation, right? And if you look at now the case of Lonsdale, in the last few pages of the notes here now, this concerns a shoe salesman who was a commercial agent. And the case went, first of all, to the Court of Appeal, which delivered the judgment, for which the House of Lords today has affirmed or confirmed. So that is the correct position now. And to highlight now the key point, right, where the court said that the French position or the French interpretation is inappropriate. The French position or the French case laws was such where they use a 2-year rule. And they said that this 2-year rule is to be dismissed because it does not involve any attempt to find out the true extent of the agent's loss. So here is where, in a way, the English judges are interpreting the Regulation 17.7 on compensation through the eyes of an English lawyer, and said that we must not blindly compensate either, and that we should not use the French approach, where many of the earlier French cases had taken very blindly, very mechanically, an automatic position, like a default position, where under compensation in France you get 2 years. Whether it's this case or another case, 2 years. Whether it's this industry or another industry, 2 years. So it was a very mechanical application of compensation in using a 2-year rule approach, which the English judges, and I think rightfully speaking, is now questioning, why is it a 2-year rule? What is the basis for a 2-year rule? And they said that there's no reasoned attempt. There's no justification as to why we were to award such. And so that's why they dismissed the 2-year rule. So the implication for now about Lonsdale is this, is that where the judges are no longer following the French case law approach, instead they are now laying down its own principle. Now, compensation still remains a French concept, just that they are no longer following the French judicial interpretation of the compensation concept. And what they did say was this, right? And this point 2 now is the part that is important. I highlight this now in its entirety, where the court said that the purpose of Regulation 17 was to provide the agent with compensation for loss, But the loss is not the loss he suffers, but rather loss of the commercial goodwill attaching to the agency business. And they now say this, and this part now is the last part is important, that it should be assessed based by reference to the value of the agency business at the date of termination. So if you have it in your notes now, this part you want to highlight. This part is important, that it should be assessed by reference to the value of the agency business at the date of termination. So what the court is now saying is this, that when we award compensation under Regulation 17, it ought not be a mechanical 2-year rule position. Rather, we look at the value of the agency business. This includes goodwill or any other factors for which we can rely on based on the industry, based on the circumstances, to then ascertain what is the likely value of the business. In other words, if someone else were to buy over the agency business now, how much would he pay for it? What is the value of the agency? The value now is the value that we will give that commercial agent for all his past efforts. So back to now here in this slide, in Lonsdale now, right, the focus now is this. I'll just copy and paste, so it's easy. Right? The court is saying that the compensation should be by reference, right, to the value of the agency business at the date of termination. Includes goodwill of the business or of the agency and other facts, circumstances as well. Whatever other circumstances where it helps you to determine the value of the agency, this is what we'll now give, right, as compensation. So you can read the other paragraphs on your own, and in fact in your notes there are, I think, about 3 or 4 cases which I've added in post Lonsdale, right, where these are later cases, right, post Lonsdale. These are later cases that had applied Lonsdale principle, and so today the position is clear. No longer use the 2-year rule approach, and we look at various factors. And in these various cases now, there are various factors which the court had used to determine what is the value of the agency business, and then that was the amount they used to compensate the agent. So with that, we have finished this whole lecture on agency. And if you have any questions, you can feel free to email me. I mentioned this before in lectures. I have a commercial law Facebook page. It's David Chung Commercial Law, and you can go online to look up for things I may post every now and then. These are thoughts I have. These are responses I have to students who ask me questions, and so when I feel that it's beneficial to my students, I would post online on Facebook. So it's my way of trying to make sure that everybody has similar information. But of course, for you now to go online to have a look at those posts, and then of course to read up further, you find that is of benefit to you. Okay, so with that, I end this lecture. Thank you so much.